This part will remain same for all 95 students. This part will remain same for all 95 students. Okay, this intro will remain same for all 95 students. Only this and this is only the uniqueness that you are bringing, means just 10% of the overall content. That will give you 0.5 extra. अगर पहला वाला 95 people लिखेंगे तो ये वाला तो 99 people लिखेंगे. But again, this will be the differentiating factor and it is in line with the demand of the question also. And case laws, बाकी आपके सारे केस लॉज इसमें है इंपॉर्टेंट वंस, इंक्लूडिंग द रिसेंट 2026. लिविंग कॉन्स्टिट्यूशन रिजेक्ट रिजिड टेक्सचुअलिज्म एंड इवॉल्व्स विद टाइम टू मीट चेंजिंग नीड्स. कॉन्स्टिट्यूशन के रिलेटेड कोई भी फिलोसॉफिकल क्वेश्चन आए तो रिमेंबर दिस वुडरो विल्सन कोट कि कॉन्स्टिट्यूशन हैज टू बी डार्विनियन इन स्ट्रक्चर and in practice. Darwinian law is basically with respect to the adaptability. So rather than not writing anything, you can read this. एक तो mark मिलेगा. I'm not saying you will get 8 marks for this particular question, but at least if other are getting 4, you will end up with 5. That's an age that you will get. So let's start. The very first question, it was on the constitutional morality. Now combined ethics and GS2, you had 4 questions in last 5 years on constitutional morality. So next year also you can expect a question on the same theme either in GS2 or in GS4. Okay, so whatever the question on constitutional morality is, there are 2 scholars out of which at least one has to be there into your answer. The one is George Groth. So basically he is the one who has given the concept of constitutional morality. And secondly, in context of India, it was given by Ambedkar. Okay. So George Groth, you can either use to highlight the core features of constitutional morality, or you can give the definition of the constitutional morality given by George Groth. That will be this only. Okay. This and Ambedkar's quote. Constitutional morality is not a natural sentiment, it needs to be cultivated. So that introduction, that quote you can use, or you can use George Groth. Okay, or you can use both if it is a 15 marker question. First, now second part is with respect to the decoding of the question. So this was fairly straightforward question. Constitutional morality is rooted in constitution itself. First part, wherever you see the word and, that means always check whether you can create 2 separate headings from that particular statement. Kabhi bhi. Again, not necessary it has to be done at all in all the answers, but that is one of the criteria that you can use to bifurcate your answer. Okay, so this is the first statement, and here as there is no directive, because explain the doctrine, that is the second part of the question. So this is your implicit demand. Okay. Then explain the doctrine of constitutional morality with the help of relevant judicial decisions. That is your second demand. Now if you see this particular question, if you go with the standard format of structuring the answer, what you will do basically is you will define the question in, you will define the concept of constitutional morality. Okay, the first, the definition of constitutional morality, because anyway they have asked you to explain the concept. So by default in this particular question, it will be definition of constitutional morality, which is adherence to the core principles or spirit of the constitution. Okay, then you can write in this way, or you can give the flowchart also as per George Groth. It involves paramount reverence to constitution, then enabling open criticism of authority, And third, public reason restraint by institutions. So you can use the flowchart method as well. Just to set the context, because constitutional morality जैसे मैंने कहा in last 5 years itself 4 बार आ चुका है, मतलब हर कोई इस पे लिखेगा ही. Everyone knows the concept of constitutional morality. That means you need to bring in some different aspect, or you need to highlight your knowledge depth in such question. ठीक है, जो डीएनए टेस्टिंग वाला जो क्वेश्चन था, अगेन वो वाला क्वेश्चन किसी को नहीं आता था. सो देयर इवन इफ यू प्रोवाइड द जेनरिक पॉइंट्स बट रिलेवेंट पॉइंट्स, there you would get higher mark than others. But such questions which are very basic or which are from the core themes कि जिस पे आपको पता है हर कोई लिखने वाला है, so there you need to show your knowledge depth. And this is why I didn't use the definition paramount reference by George Groth in the introduction. I defined introduction separately and I highlighted this because that will, or this part is going to be the X factor into my answer. ठीक है, जो सिविल्स डेली के बच्चे नहीं है उनमें से कोई किसी को पता भी नहीं होगा ये, तो यू हैव दैट एडवांटेज. सो जस्ट रिमेंबर दैट. देन नाउ जैसे मैंने कहा था कि एज द वर्ड एंड इज देयर यू कैन थिंक ऑफ डिवाइडिंग. सो क्या कहा इन्होंने, रूटेड इन कॉन्स्टिट्यूशनल इटसेल्फ and founded on essential facts. Now if you see, you can't divide it. Rooted in constitution one heading and founded on essential facts another heading, both are one and same, right? So there is no need to divide two headings. You can provide a single heading, essential facts and rules, roots within the constitution. Okay, so within the constitution again automatically constitutional provisions will become your subheading, and how they uphold constitutional morality, that will be your elaboration. Okay, because what they have asked ki it is based upon essential facts and roots within constitution. So facts or roots or provisions of the constitution becomes your subheadings. Preamble, fundamental rights, DPSP, checks and balance, democratic processes. Okay, these becomes your subheadings. And in elaboration, all you have to do is you have to link it with constitutional morality. So what are the features of constitutional morality within preamble? Justice, liberty, equality. It acts as a moral compass and mandates preservation for justice, liberty and equality. Or simply it acts as a moral compass for upholding and promoting justice, liberty and equality. Then fundamental rights protects dignity, autonomy, equality. And then notice Singh Johar. Either this or within fundamental rights also you can make two subpoints. Okay, fundamental rights are of two types. One, enabling one, and second, negative fundamental rights, which restricts the power of the state. Right, तो यहाँ पे इसके नीचे आप दो भी लिख सकते हो. तो fundamental right, this is going to be your point. Then sub point or A, protect dignity and autonomy. आगे example नवतेज सिंह जोहर. ठीक है. Second, he keeps check on state power. Okay, so limited state power is also the fact or the important pillar of the constitutional morality. Here you can give example of privacy judgment. Okay, under it also you can give two subpoints. That is also fine. And then in DPSP provide moral compass for social and economic, or upholds social and economic justice. Okay. And then institutional checks and balance, separation of powers, judicial review, federalism. All these constitutional provisions uphold the constitutional morality, and the justification you give the judgment Keshwanand Bharti. Second, democratic process again, free and fair elections, executive accountability, judicial independence. If you want to give the example, NJSC. Okay. Here again, here if you want to promote justice, liberty, equality, the example you can give of Nari Shakti Adhiniyam, which provides for gender justice also and gender equality also. Again, in a way, it also acts as a positive liberty mechanism for women. So that example also you can give. Okay. Is this part clear? All right. Now the next part, this we have addressed. So we have explained the concept of constitutional morality. Now, so explain the concept of constitutional morality. So this part, this is the implicit part plus this implicit part plus this explicit part. Both we have covered in one page. Now second explicit, with the help of relevant judicial decisions. Then now you simply give judicial decisions. Okay, so judicial decisions will be, these are your judicial decisions. So here also you can go in two ways. Okay, one simpler way is you simply mention judicial or the case as the subheadings and provide the elaboration how it links constitutional morality or how that judgment upholds constitutional morality. Okay, either that or you can, this is the one way where you are making judicial decisions as subheadings. The another way here is you can mention the the principles of constitutional morality, and under it you can give the judicial decision. So for example, first, the superiority of constitutional morality over social social morality. Okay, the two judgment will come. You don't even need to give the full detailed elaboration. Okay, simply again Navtej Singh Johar case decriminalizing homosexuality. Then with respect to the transgender verdict. Okay, third Sabrimala verdict upholding the gender equality. तीन सब पॉइंट करके एक लाइन में आपका वो पॉइंट बन जाता था. तो दैट इज फर्स्ट. सो दिस इज विथ रिस्पेक्ट टू दी सोसाइटी. सेकंड, वही आपके पॉइंट्स आएंगे कि प्रिवेंटिंग मेजोरिटेरियनिज्म. ठीक है, तो इसमें आप कोई पॉइंट डाल सकते हो कि जैसे केशवानंद भारती लिमिटेड द अमेंडिंग पावर ऑफ द पार्लियामेंट टू बेसिक स्ट्रक्चर एंड कॉन्स्टिट्यूशनल morality. तो दैट प्रिवेंट्स मेजोरिटेरियनिज्म. ठीक है. थर्ड, अब जेंडर जस्टिस आप सेपरेटली भी दे सकते हो या फिर ऐसे भी, या फिर अपहोल्डिंग सेपरेशन ऑफ पावर एंड फेडरलिज्म. दिस कैन बी योर सबहेडिंग. उसके आगे आपकी एनसीटी दिल्ली, that case can come. So this is also the alternative way that you can give, but this much is sufficient. ये वाला, this is fine. I'm just giving you the alternative way so that आपका brainstorming थोड़ा सा stronger हो. ठीक है. अगेन क्वेश्चन में दो कौन से थीम से समझो. तो वन थीम वाज कॉन्स्टिट्यूशनल मोरालिटी, सेकंड वाज जुडिशियल डिसीजंस. So either judicial decisions will become your subheadings or constitutional morality principles will become your subheading. Both are fine. So in this way you need to structure your answer, and in this way you need to structure your thought process. ठीक है, clear है? All right. Now अब यहाँ पे ऑलरेडी इट इज अ 10 marker question and we have sufficient content depth. We have covered sufficient point, so there is no need to give any issues or way forward, or otherwise आपके पास, if you don't have the content, then you can apply 80-20 rule here. And here you can simply make a table of issues way forward with respect to constitutional morality. But you just need to remember, जितना वेटेज मैंने यहाँ दिखाया है उतना ही वेटेज उसका जाना चाहिए, ठीक है, बिकॉज यू आर गोइंग बियॉन्ड द डिमांड हियर. इफ यू टेक लॉट ऑफ वेटेज इट विल बैकफायर एंड निगेटिव मार्किंग होगी, ठीक है. बट एनी वे वी हैव सफिशियंट कंटेंट फॉर दिस, सो दिस पार्ट इज नॉट नीडेड, ठीक है. इन कंक्लूजन अगेन, रादर देन यूजिंग अंबेडकर, बिकॉज अंबेडकर सभी यूज करेंगे, बहुत सिंपल कोड बोला था उन्होंने तो सबको याद है, वो तो सब लिखेंगे. दैट्स व्हाई आई हैव गिवन दी राजीव भार्गवा. As per Rajiv Bhargava, it embodies a constitutional patriotism that enables unity in diversity while upholding pluralism. So with this, you can conclude. Now see, if 100 people are writing the mains, 95 of them will write the answer of this particular question. But only few of you guys will be having the uniqueness and content depth into the answer. ठीक है. अब यहाँ पे भी अगर देखोगे तो this part will remain same for all 95 students. This part will remain same for all 95 students. ठीक है. This intro will remain same for all 95 students. Only this and this. This is only the uniqueness that you are bringing, means just 10% of the overall content. That will give you 0.5 extra. This is how you become the topper. ठीक है. क्लियर है विथ रिस्पेक्ट टू कॉन्स्टिट्यूशनल मोरालिटी? अभी कोई भी क्वेश्चन आया तो ऑलराइट. देन सेकंड, discuss the possible factors that inhibit India from enacting its citizen a uniform civil code as provided in the DPSP. ठीक है. अब ये भी, this question was on 2015. I asked this because again uniform civil code is in news. So already factors hindering uniform civil code they have asked. So this year they can ask you the question with respect to the suggest a roadmap, ठीक है, to enact a uniform civil code or examine the need for UCC in India. Means arguments in favor of UCC and arguments against or challenges in UCC. This question again you can get because अब 10 साल से ऊपर हो गया है, ठीक है. Again intro will remain same कि under article 44 aims to replace fragmented religion based personal laws with one secular code. Just to have the keyword into the introduction, just box it, for all citizens. ठीक है. Now comes the fact file. अब यहाँ पे you know with respect to what is going on with respect to the uniform civil code कि उत्तराखंड has enacted, Assam enacted 2 days ago. अब ये आंसर उससे पहले लिखा था, तो by that time Assam had only banned polygamy, but Assam also enacted UCC 2-3 days ago. That means in 2026. So Uttarakhand UCC in 2025, Assam UCC in 2026. And third, the Supreme Court itself highlighted need for UCC for in Sarla Mudgal case. So this is the Supreme Court judgment. Now what happens is, why I gave this into the, or why I put this into the fact file is that again this is not a rocket science, सबको पता है. Everyone knows the Sarla Mudgal case, Assam case, Uttarakhand case. ठीक है. That, but what majority of the aspirants will do is they will put this particular content in between your main body. So there are high chances that the evaluator might miss it. Okay, so if you put it into the fact file, Now if you see the answer, the first thing that you will notice in the answer is the fact file. So the evaluator is going to notice this fact file, कुछ भी हो जाए. ठीक है, that means your this becomes your X factor. बाकी लोग बीच में लिखेंगे, you are putting it into the single heading. ठीक है. Now coming to the factors again, in my answer also I have simply written the factors. The law commission itself has concluded that it is neither necessary nor desirable because of diversity. Then lack of consensus and politicization, opposition by parties like AIMIM. Then religious autonomy concerns, friction between 44 and 25. Then tribal autonomy concerns, कि 6th schedule state or the tribals fear UCC will destroy their indigenous socio-cultural identities and customs. That is why in majority of the UCCs, tribals are excluded. Then federalism, ki uniform civil code is a concurrent list power. So it will attack the state on the attack the state power with respect to the concurrent list. Okay. Then with respect to the legal diversity, within the Hindu community also, the maternal uncle marriages in South India, which North India bans. So which one of the provision will you keep into the UCC? So within Hinduism also you had the different customs. And last, because of diversity, there is lot of legal pluralism in India, specifically because of the tribals or customs between north and south, customs between different castes. So because of all that diversity, combining them into the single code is difficult task. Now these are the points. ठीक है, अब इसको अब याद करोगे whatever you do, but the best way or the better way would have been a classification of the points of factors. Simply classify first political factors. Okay, political factors is going to be your heading. Within that, obviously, you have 2 points. One is politicization, and second, federal concerns. Okay. Second, you come to the social factors. लॉ कमीशन का पॉइंट पहले ही लिखो, उसके बाद व्हाट आर दी सोशल फैक्टर्स. वन इज दी ट्राइबल इश्यूज. सेकंड की minority fear, and third the within Hinduism itself, the diversity within Hinduism. These will be 3 social factors. Then comes the third aspect, that is legal institutional aspect. Okay, so legal institutional constitutional. So first key conflict between article 44 and article 25, ब्रैकेट में ही लिख दो, राइट टू प्रोफेस प्रैक्टिस प्रोपोगेट रिलीजन. ठीक है. देन मल्टीप्लिसिटी ऑफ द लॉज, makes combining them into the single code difficult. तो ऐसे क्लासिफाई अगर आप करोगे दैट वुड बी इवन मोर बेटर. ठीक है. तो पॉलिटिकल बेसिकली पाइज अप्रोच इटसेल्फ. ओनली थिंग इकोनॉमिक कोई डायमेंशन आएगा नहीं. पॉलिटिकल, सोशल, लीगल. ठीक है, ये याद रखो. देन यू गिव दी वे फॉरवर्ड. विद इन वे फॉरवर्ड जब भी कोई कंटेंशियस इश्यू आए, ठीक है, जैसे फॉर एग्जांपल सिडिशन इज देयर, और यू कैन आल्सो एक्सपेक्ट अ क्वेश्चन ऑन डिफेमेशन दिस ईयर. डिफेमेशन वाज आल्सो इन न्यूज. ठीक है, फिर सिडिशन पे आ सकता है. सो ये बहुत कंटेंशियस इश्यूज है. देयर आर बोथ आर्गुमेंट्स इन फेवर, आर्गुमेंट्स अगेंस्ट. सो In such questions, okay, while giving the way forward, few common way forwards that you can give. Okay, first is a reasoned debate. Okay, to develop consensus. अब विद इन पार्लियामेंट अब कह सकते हैं फर्स्ट. ठीक है. सेकंड इज स्टेप लैडर मॉडल. ठीक है. सो स्टेप लैडर मॉडल फॉर जैसे फॉर एग्जांपल विथ रिस्पेक्ट टू डिफेमेशन यू कैन से डिक्रिमिनलाइजिंग डिफेमेशन कैन बी द फर्स्ट स्टेप in keeping the civil defamation within uh, uniform civil code also step ladder model gradual issue based legal updates rather than direct central code. ठीक है. तो ये दो याद रखो on any contentious issue. First, try to develop consensus based upon the reasoned debate. And second, gradual change. ठीक है. और इसको पीसमील चेंज भी कह सकते हैं. ठीक है. दिस ऑल्सो यू कैन मेंशन. ना उसके बाद फिर प्रायोरिटाइज जेंडर जस्टिस जो भी आपके मेजर इश्यूज है. ठीक है. इफ यू डोंट हैव दिस स्पेसिफिक वे फॉरवर्ड्स सिंपली गो थ्रू द इश्यूज दैट यू हैव मेंशन एंड प्रोवाइड द सॉल्यूशन फॉर देम. ठीक है. जैसे फॉर एग्जांपल अब हमने फियर ऑफ माइनॉरिटीज कहा था एंड देन वी टॉक्ड अबाउट द ट्राइबल्स. सो दोनों का सॉल्यूशन दे दो. सो कीप fifth and sixth scheduled tribal zone out of initial rollouts. ठीक है. Then institutionalize dialogue. Use law commission to hold talks with religious head and community elders of minorities. ठीक है. तो जो इश्यूज है उन्हीं के वे फॉरवर्ड आपको देना है. ठीक है. या फिर गिविंग रिप्रेजेंटेशन टू दी माइनॉरिटीज इन दी ड्राफ्टिंग कमेटी. तो ऐसे वे फॉरवर्ड आपको देना है. ठीक है. एंड देन कंक्लूजन अगेन यू लिंक इट विद द constitutional morality. So implementing uniform civil code demands again यहाँ पे law commission itself has said that it is not necessary in India. ठीक है. That means you can't take a clear stand with respect to whether it should be implemented or not. Because here you need to take a balanced stand. The balanced stand would be you need to balance constitutional morality with pluralism. Or simply way forward lies in balancing constitutional morality with India's rich pluralism. That's it. That would suffice. ठीक है. क्लियर है. यस. ऑलराइट. नेक्स्ट, the constitutional perspective of gender justice with the help of relevant constitutional provisions and case laws. Again, gender justice का क्वेश्चन है तो यूएन. ठीक है. If you want, you can put fact file here also. India's ranking with respect to, you can put fact file here also with respect to the India's ranking in gender inequality report or if there is any gender justice report etc. अगर आपको पता है you can put. Okay, that is also fine. But remember this definition because gender justice is a common theme across GS2, GS1 and GS4. So ये definition you need to mark up of UN women. ठीक है. This. Now comes the second part की explain constitutional perspective of gender justice with the help of relevant constitutional provisions. So आपकी heading should be constitutional perspective of gender justice and or constitutional provisions upholding gender justice. ठीक है. यहाँ पे भी again I have given you two way format. The one is again simple constitutional provision you mention as the subheading. ठीक है, और उसके आगे यू सिंपली प्रोवाइड द इलेबोरेशन कि राइट टू लाइफ विद डिग्निटी, और आर्टिकल 21 इसमें अगर देना है तो दैट you can give that judgment, right to choice, ठीक है, और right to marry person of choice, ठीक है. So that also as an example you can give. So one way is this, or second, you make constitutional perspective of gender justice as your subheading. So what is the constitutional perspective of gender justice? It is gender equality. Second, it is dignity. And third, it is autonomy. If you want, you can also add liberty. Fine. But dignity article 21 में आ जाएगा. So this you can make as your subheading. So equality. Under it you can write points. So when article 14, 15, 16. Second, yeah, article 39, equal pay for equal work. That can also be your point. Okay. Second, dignity. So article 21, right to life with dignity. Okay. That. And then article 51 AE. Again, that is with respect to the dignity. And third, with respect to the autonomy. Here, 73rd, 74th Amendment. 33% reservation in PRIs. Okay, so this classification also you can go for. So either you put fact file or this classification. That will just bring more uniqueness. And that will show you the content depth. और वो भी क्वेश्चन में दिया है इसीलिए. Explain constitutional perspective on gender justice. So what is constitutional perspective on gender justice? It is this: equality, dignity, autonomy. ठीक है. So this would have made a better answer, this classification. इसीलिए क्वेश्चन यू नीड टू रीड इट प्रॉपरली. अब अगेन ये भी क्वेश्चन कोई ऐसा बहुत डिफिकल्ट नहीं है. ठीक है, अगर पहला वाला 95 पीपल लिखेंगे तो ये वाला तो 99 पीपल लिखेंगे. बट अगेन दिस विल बी द डिफरेंशिएटिंग फैक्टर एंड इट इज इन लाइन विद द डिमांड ऑफ द क्वेश्चन ऑल्सो. एंड केस लॉस, बाकी आपके सारे केस लॉस इसमें है ही, important ones, including the recent 2026 one. इसमें कोई रॉकेट साइंस नहीं है. देन कंक्लूजन, यू हैड वन ऑफ अंबेडकर. अब इसमें भी इफ यू वांट यू कैन पुट इश्यूज वे फॉरवर्ड का टेबल, इश्यूज इन जेंडर जस्टिस एंड वे फॉरवर्ड. बट अगेन 10 तो हमने जजमेंट्स ही दिए हैं, यहाँ पे भी 5 पॉइंट हो गया, तो 15 पॉइंट्स आर ऑलरेडी देयर. Our target is to write 12, 11 to 12 points in 10 mark. When you are able to fulfill that, ठीक है, at the end there is no need to go for that 80-20 rule if you are able to fill the pages. ठीक है, ये क्लियर है. द क्लासिफिकेशन यही चीज है. दिस क्लासिफिकेशन इटसेल्फ इज व्हाट आई एम गोइंग टू टीच यू द मोस्ट. ये क्लासिफिकेशन द बेस्ट मैंने अगर आपको देखना होगा द बेस्ट यूटिलाइजेशन ऑफ क्लासिफिकेशन मेथड, इट्स इन दी श्रुति शर्मा आंसर्स. ठीक है, ऑलवेज. देन नेक्स्ट, do you think that the Constitution of India does not accept strict separation of power, rather it is based on the principle of checks and balances? ठीक है, again explain है, and statement itself is establishing both sides. ठीक है, so basically you have to give both sides की one principle of separation of power under Indian Constitution, and second, checks and balance. यही दो हेडिंग्स आपकी बनी होगी. Anyone else has made any third heading? Yes, इसमें थर्ड हेडिंग आएगी कोई? So the first heading is separation of power under Indian Constitution. Second, checks and balance under Indian Constitution. What else? So just see what they have said. Ki Constitution of India does not accept principle of separation of power. So you need to tell why it does not accept. And then you explain the checks and balance. Okay. Again, separation of power is the introduction. You go with the origin or history. Because definition though obviously will be there, but along with the definition, you mention the Montesquieu. And again, 100 में से 70 people will mention Montesquieu also. Okay. So what extra you will be mentioning is book, Spirit of Laws. Because again, separation of power is the key theme. You can get question on separation of power this year also. Just remember this book. Don't simply mention Montesquieu, mention his book also and box it. Okay, intro itself will be enriched. Divide state power into legislative, executive, judiciary to prevent concentration and arbitrariness. Okay, and then separation of power in the constitution. You provide the articles. Okay, Article 50, Article 122 and 212. Okay, courts cannot question parliament or state legislature. 121 to 11, conduct of judges cannot be discussed in parliament. 361, president and governors enjoy immunity, are not answerable to courts. तो ये. Then you give the reason. Do you think Constitution of India do not accept principle of separation of power? Okay, so these are few provisions. Okay, however, strict separation does not exist due to. Okay, so if the question would have been only this, do you think Constitution of India does not accept principle of separation of power? So arguments in favor and arguments against you would have given. Right. So these are your arguments in favor, but where are your argument against? ठीक है, तो यहाँ पे आपका you need to give the reasons. It does not accept because India has the parliamentary democracy. Because of parliamentary democracy, executive is drawn from legislature. Second, provision of delegated legislation. So it gives lawmaking power to the executive. Third, judiciary functions as legislature. Judicial functions of legislature. So legislature act as a judiciary. So in case of privilege motions or impeachment of judges, or in case of anti-defection law, where speaker acts as a judge. Then judiciary functions of executive. Judicial functions of executive. Similarly, you also have law-making functions of judiciary, Article 141. Executive functions of judiciary, Article 142. And then principle of checks and balances. यहाँ पे you highlight the checks on each. So first, judicial review. कि judiciary can strike down unconditional laws and executive actions both. Example in JC judgment. Legislature control executive via question motions, no confidence votes. ठीक है. Executive controls appointments of judges. ठीक है. Then judiciary reviews laws for conformity with fundamental rights and basic structure. Legislative control over judiciary की with respect to the impeachment motion or 2018 amendment to the Atrocities Act. So in the Subhash Mahajan case, SC invalidated few provisions of Atrocities Act. So Parliament invalidated SC judgment by enacting the new act. Okay, so with that also we have the checks and balance. Okay, that, and then conclusion. Again, you can use a quote. Power corrupts because the purpose of separation of power or checks and balance is to prevent concentration of power. So power के related है तो power corrupts, absolute power corrupts absolutely. Thus, checks and balances and separation of power are essential to prevent tyranny and preserve democracy. So this should have been now. ये वाला question. The Constitution of India is the living instrument with capabilities of enormous dynamism. It is a constitution made for progressive society, illustrate with special reference to expanding horizons of right to life and personal liberty. Okay, so first, again, a simple first, the Constitution of India has enormous dynamism. Second, it is a constitution made for progressive society. And third, expanding horizons of right to life and personal liberty. So the again, as far as the constitution as a living document is concerned, X factor से ही है कि the living constitution reject rigid textualism and evolves with time to meet changing needs. कॉन्स्टिट्यूशन के रिलेटेड कोई भी फिलोसॉफिकल क्वेश्चन आए तो रिमेंबर दिस वुडरो विल्सन कोट कि कॉन्स्टिट्यूशन हैज टू बी डार्विनियन इन स्ट्रक्चर एंड इन प्रैक्टिस. डार्विनियन law is basically with respect to the adaptability, survival of the fittest. So constitution also needs to adapt with changing times to remain relevant. ठीक है, इंडिया के कॉन्स्टिट्यूशन में 100 से ज्यादा अमेंडमेंट्स हुए हैं. दैट इज व्हाई इंडियन कॉन्स्टिट्यूशन इज स्टिल रिलेवेंट. ठीक है, श्रीलंका में 2-3 हो गए, बाकी नेपाल में 2-3 हो गए. ठीक है, पाकिस्तान में एक था वो भी डेड हो गया. इंडियन कॉन्स्टिट्यूशन सर्वाइव्ड ओनली बिकॉज ऑफ दिस एडेप्टेबिलिटी. ठीक है, सो ऑलवेज you remember this, Woodrow Wilson. You can use it anywhere. Then briefly, as this is the first statement, implicit demand, enormous dynamism, so expanding interpretation of fundamental rights, democratic federal evolution to amendments, over 100 amendments so far. That also highlights the dynamism. And judicial doctrines expanding the scope of constitution. जैसे basic structure doctrine. Then second part, constitution made for progressive society. ठीक है, again here it is two ways. ठीक है, so constitution made for progressive society means you can give constitutional provisions as the subheading, or you can give pillars of progressive society as the subheadings. So what will be the pillars of progressive society? Again, equality and equity, justice, liberty and freedom. यही तीन आएंगे. प्रोग्रेसिव सोसाइटी इज नथिंग बट सोसाइटी बेस्ड अपॉन जस्टिस, लिबर्टी, इक्वालिटी, प्रीएम्बल वाले प्रिंसिपल्स. So you can classify your points under that also. Okay, that is the one way. Second, simple structure. Again, progressive society, social justice, gender equality, constitutional provisions, political equality, universal adult franchise. Then welfare state. Okay, 39B and C or Article 45. Secularism and fraternity, promotes unity in diversity, prevent majoritarianism. Okay, so this is constitution made for progressive society. You can classify points under these three also. Okay, then expanding horizons of right to life and personal liberty. अब ये वाला again all of you must have written. All you had to do right, is the right Supreme Court judgments, right? By what else the Constitution, the interpretation of or the scope of Article 21 was expanded? Yes, यहाँ पे तो बोला नहीं है ना उन्होंने. Illustrate with special reference to expanding horizons of right to life and personal liberty. Through judicial pronouncement नहीं बोला है उन्होंने. So apart from judicial pronouncement, Article 21 was also expanded in scope through amendments. The right to education as a part of Article 21A that was introduced through the 86th Amendment. 44th Amendment ensured immunity of right to life even during emergency. So that is also basically enhancing the scope itself. ठीक है, so ये judgments वाले part, that is fine, you can write कि right to livelihood, Olga Telis, right to education, right to clean environment. Subhash Kumar was the first case. Then MC Mehta cases, right to health, right to privacy, die with dignity. The recent Harshit Rana case also you can mention. Right to internet access, right to marry person of choice, ये शफीन जहाँ. Then right to menstrual health and hygiene, ये recent जया ठाकुर. ठीक है, तो ये केस लॉज तो लिखेंगे, बट हाउ मेनी ऑफ यू हैव रिटन दिस एक्सपांडिंग स्कोप थ्रू द अमेंडमेंट्स? ठीक है, दिस इज व्हाट गिव्स यू एक्स्ट्रा. इसमें तो एक्स्ट्रा 1.5 मिलेगा आपको. ठीक है, दिस एंड देन कंक्लूजन अगेन. ग्रैनविल ऑस्टिन रिमार्क्ड, द कॉन्स्टिट्यूशन इज अ सोशल डॉक्यूमेंट एमिंग एट ट्रांसफॉर्मिंग सोसाइटी थ्रू लॉ. So this quote you can write, but anyway, in the introduction itself we have given one scholar, तो जरूरी नहीं है. तो again, what conclusion we will write? कि thus Constitution of India is the pillar of the this India's emergence as the mother of democracy. Yeah. और if you want, इसी को rephrase कर दो कि the dynamism of constitutional morality and for progressive society. So इसी को कर दो कि this Indian Constitution, through its dynamism, has transformed into progressive charter of human rights. तो क्वेश्चन के स्टेटमेंट को भी आप रिफ्रेश करके लिख सकते हो. दैट इज ऑल्सो फाइन. ठीक है, अनदर इफ यू डोंट हैव सफिशिएंट कंटेंट, यहाँ पे यू कैन हाईलाइट द इश्यूज वे फॉरवर्ड. वन इशू इज, ठीक है, फ्लेक्सिबिलिटी with respect to the amendments. Second issue, judicial overreach. ठीक है. Third issue you can mention कि this no powers to state to introduce amendment unlike US. बट वे फॉरवर्ड देने की जरूरत भी नहीं है. सिंपली बस इश्यूज भी अगर लेते एंड कंक्लूजन भी दे देते तो भी चलता. बट अगेन दिस वाज सफिशिएंट एज अ एक्स फैक्टर कि थ्रू अमेंडमेंट्स तो इश्यूज लिखने की जरूरत नहीं है. ठीक है, तो दिस इज हाउ यू नीड टू थिंक. यहाँ पे बोला नहीं गया है कि जुडिशियल प्रोनाउंसमेंट्स एक्सपांडिंग होराइजंस उन्होंने पूछा है, तो एक्सपांडिंग होराइजंस थ्रू अमेंडमेंट ऑल्सो यू शुड हैव रिटन. ठीक है, क्लियर? ओके, नाउ कम्स द नेक्स्ट क्वेश्चन. तो दैट दिस had to write the answer of that again. So right to privacy is intrinsic to right to life and personal liberty and is inherently protected under Article 21 of the Constitution. So basically, you have to establish the linkage between right to life and right to privacy. So in this reference, discuss law relating to DNA testing of child in the womb to establish his paternity. ठीक है, सब ये थोड़ा सा डिफिकल्ट क्वेश्चन था. To establishing the linkage between right to privacy and Article 21 is itself, it, you can write 2 to 3 points, but filling one entire page is difficult. Second, DNA testing तो पता भी नहीं होगा. ठीक है, laws relating to DNA testing to establish paternity. अब in such cases, what you need to do? First, introduction automatically. क्या privacy is the, उससे पहले भी बहुत बार क्वेश्चन आया है. The first you give the quote कि privacy is the foundational core of human dignity. Justice D.Y. Chandrachud. Then you mention the Puthuswamy judgment. ठीक है. Second, right to life intrinsic to life and personal liberty under Article 21. ठीक है. So how privacy is intrinsic to life and liberty under 21, that you need to establish. ठीक है. So यहाँ पे simple thing you need to remember or you need to think is the different dimensions of right to life and liberty. So what are the dimensions of life? It is dignity, it is autonomy. Okay, with respect to the freedom, right to liberty, it is with respect to the choice or freedom. And again, जो मैंने पहले पॉइंट में बोला था, fundamental rights also restrict the power of state. Right, so right to privacy also restricts power of state. ठीक है. और a state's power of surveillance that impacts the liberty of citizens. ठीक है. तो ये तो आपको पता है ना, राइट टू लाइफ का पार्ट, डिग्निटी, ऑटोनॉमी, चॉइस, फ्रीडम. ऑल यू हैव टू डू इज यू हैव टू लिंक इट विथ प्राइवेसी. जैसे पहला, इंफॉर्मेशन प्राइवेसी कि प्रोटेक्ट्स पर्सनल डेटा, आधार डेटा, मेडिकल रिकॉर्ड्स, ऑनलाइन फुटप्रिंट्स. ठीक है. सो राइट टू प्राइवेसी प्रोटेक्ट योर informational privacy, which is also linked to the dignity. Second, it protects intimate zones or the private sphere like sexual orientation, the marriage choices, procreational or reproduction choices, all those. ठीक है. Third, again, with respect to the autonomy. So decisional autonomy by recognizing the, just a second, by recognizing the sexual orientation. कि नवतेज सिंह जोहार केस, decriminalizing homosexuality, where it held that sexual orientation is the part of privacy. ठीक है. So autonomy आ गया. Then bodily integrity, कि reproductive choice as a part of privacy and dignity. Then negative, कोई भी फंडामेंटल राइट रिलेटेड आपका क्वेश्चन आ जाए तो चेक ऑन सर्वेलेंस पावर ऑफ द स्टेट. एग्जाम्पल, the Navtej Singh Johar or the Aadhaar, not Navtej Singh Johar, the Puttuswamy judgment or the Aadhaar judgment itself. ठीक है. अब ये तो आपके 5 पॉइंट्स बन गए by just thinking over the different dimensions of right to life. ठीक है. अब the expansion of right to life itself has come twice. इससे पहले वाले में भी एक्सपांशन ऑफ राइट टू लाइफ आया था, यहाँ पे भी राइट टू लाइफ मतलब आर्टिकल 21 है. सो जस्ट रिमेंबर these aspects of right to life. So dignity, liberty or freedom, autonomy, choice, bodily integrity, and information privacy. ठीक है. निगेटिव पॉइंट कोई भी फंडामेंटल राइट का होता है, चेक सर्वेलेंस पावर ऑफ द स्टेट्स. Now, however, it is not absolute but has reasonable restrictions. So the proportionality test established by Supreme Court in Puttuswamy judgment. Because a proportionality test is legality. The breach of privacy should be sanctioned by law. Second, legitimate aim. So aim should be legitimate. Just example, collecting the Aadhaar data for beneficiary identification or COVID data for public health surveillance. Okay. Third, proportionality. The extent of interference must be proportionate to purpose. Okay. If your purpose is to give food or to identify the beneficiaries of NFHS, the proportionate amount of the private data that you can sort is the Aadhaar data. तो उसके लिए you can't go collecting the data of with respect to education or with respect to health. That is not proportionate. So proportionality principle. Now DNA testing of child in the womb to establish paternity. Basically, अभी ये question पहले था. So before BNS and all. So before you had within criminal courts you had CRPC, IPC, and Indian Evidence Act. Right. So DNA testing will be under which one? CRPC, IPC, or Evidence Act? Yes. So DNA testing to check paternity. So to check paternity basically means evidence. Right. So basically the Indian section आपको पता नहीं है, that's completely fine. No need to write section. ठीक है. So उस टाइम अगर होता तो Indian Evidence Act provides for the or contains the provisions related to the DNA testing for establishing paternity. ठीक है. थोड़ा सा जेनरिक पॉइंट है, इट इज नॉट अ प्रिसाइज पॉइंट लाइक दिस कि सेक्शन 116 ऑफ it presumes that child born during the marriage or within 280 days of the dissolution of marriage is legitimate. इतना प्रिसाइज आपको नहीं पता है तो भी चलेगा, बट एटलीस्ट इंडियन एविडेंस एक्ट provides for DNA testing for establishing paternity. पहला पॉइंट तो आपका बन गया, बाकी लोगों से तो आपका फिर भी प्रिसाइज ही है, तो यू विल बी हैविंग मोर मार्क्स देन दैट. सेकंड, बिफोर द so DNA testing in the womb of the mother. So for that, for womb of the mother, you have PCPNDT Act, right? Which bans the ultrasonography or the sex selection, etc. So PCPNDT Act regulates the DNA test for establishing paternity. ठीक है. थर्ड की SC judgments. Suppose even if you don't know the case laws, okay, you can simply apply the logic of the Supreme Court. So Supreme Court will always say कि DNA testing to establish paternity cannot be routinely used. Okay, so basically Supreme Court must have set some guidelines. तो वही पॉइंट लिखो कि Supreme Court has held that कि DNA testing cannot be used routinely and has provided the guidelines for allowing the DNA testing. तो एटलीस्ट आपके 3 पॉइंट्स तो बन जाएंगे. ठीक है. सो डिस्कस लॉज रिलेटिंग टू डीएनए टेस्टिंग आपको बोला. सो यू हैव दिस क्रिमिनल कोड, you have law, you have Supreme Court judgment. At least 3 points you could have written, considering you know nothing about it. So even with zero knowledge, you can write. ठीक है. That all. Just to write it precise कि Gautam Kandu case, court cannot order DNA test regularly and no one can be compelled to give samples. And this was the 2023 case in context of which they have asked this particular question. DNA test cannot be ordered to merely establish adultery, and child has legal right to defend against having their legal status questioned. So basically means this is about the right to privacy of child. ठीक है, दैट इज अनइंटेंशनली। चाइल्ड तो खुद बोलेगा नहीं, वो तो womb में है, तो विदाउट हिज नोइंग यू आर ब्रीचिंग हिज प्राइवेसी और आइडेंटिटी। ठीक है, इवन इफ यू डोंट नो दिस मच, बट स्टिल यू कैन मेक more than generic points, and at the end you give the way forward. अब आपको पता है there is no separate law, so first point should be a separate law. But if you want to make this precise also, you can go DNA testing law or act to establish clear rules for DNA testing. Second, you know the PCPNDT Act is there. You are talking about new law. So harmonize rules with PCPNDT Act to minimize use of for sex selection. And third, as it is related to the health, so the way forward in the PCPNDT, that is strengthening accreditation and oversight of testing facilities. थ्री इजी वे फॉरवर्ड। अब क्या आ गए यहाँ पे अगेन, ये तीनों वे फॉरवर्ड भी कोई रॉकेट साइंस नहीं है, मोर और लेस दे आर जेनरिक ओनली बट विथ प्रॉपर वर्डिंग। Thus, the doctrine of eminent need and last resort is essential to protect child's right to identity and privacy. ठीक है, अगर वो भी नहीं पता है तो सिंपली दस राइट टू प्राइवेसी एक्सटेंड not only to the adults but also to the unborn child. ठीक है, expanding, और this highlights the expanding scope of Article 21. ठीक है, वैसे भी आप लिख सकते हो, so even without knowing just with smart deductions you can prepare the answer. ठीक है, is this clear? Yes, all you need to know is कि this during the pregnancy the only act that deals with the woman pregnancy is PCPNDT Act. ठीक है, सो यू शुड नो दैट, वो मेंशन करो, वहीं से आपके दो पॉइंट्स बन जाएंगे. SC judgment, even if you don't know it, based upon the question itself, SC will always say कि it cannot be used randomly or routinely. There has to be certain criteria and SC has set guidelines. ठीक है, वो आपका पॉइंट बनेगा. सो रादर देन नॉट राइटिंग एनीथिंग यू कैन राइट दिस. एक तो मार्क मिलेगा. आई एम नॉट सेइंग यू विल गेट 8 marks for this particular question, but at least if other are getting 4, you will end up with 5. That's an age that you will get. ठीक है, yes. Now last one is easy. Account for the legal political factors responsible for reduced frequency of using Article 356 by the Union government since mid 1990s. अब इसका exact opposite question can come this year. ठीक है, आने के चांसेस कम है बट दे कैन आस्क. ठीक है, तो ये imposition of Article 356 in recent years highlights the tension between the Indian federal model. Can be asked, chances कम है बट वैसे वो रिफ्रेश कर सकते थे. ठीक है, so Article 356 empowers Union to impose precedent rule when constitutional machinery fails. Now, जैसे इन्होंने क्या कहा था कि reduction from mid 1990s, that means there was very high imposition of 356 before 1990s. ठीक है, so between 1950 to 1990 it was invoked over 90 times. Exact number मुझे पता नहीं है but 90 times. ठीक है, however since mid 19 its frequency has declined. So ये reducing frequency वाला जो part है that has been addressed here. And then you first provide the static part, ground for imposition of Article 3 or presidential rule. डायग्राम से करो या सिंपल फ्लो चार्ट भी कर सकते हो, दैट इज ऑल्सो फाइन. देन यू सिंपली गो विथ लीगल फैक्टर्स. व्हाट विल बी द लीगल फैक्टर्स? सो लीगल मींस, legal factors. What are going to be the legal factors? Mostly the Supreme Court laws will be there. Okay. Then the amendments will be there. Okay. So first 38th Amendment made President rule immune from judicial review, but 44th Amendment reversed this, restoring judicial scrutiny. So there was judicial scrutiny with 44. Then SR Bommai judgment guidelines. So these guidelines की judicial review is subject to court scrutiny. Floor test की majority must be tested in the floor of the house and not in the house of the governor. Then limits on dissolution. कि assembly can't be dissolved before parliament approves president rule. So till that time, the assembly remains in the state of suspension. Only when parliament approves it, then assembly can be dissolved. Then आपको सबको पता है कि basic test SR बोम्बई में federalism has been declared as the basic structure. Just read the provisions of the Supreme Court judgments. This SR बोम्बई guidelines. And last point will be कि again as a subsequent judicial oversight as seen in cases like Uttarakhand, Arunachal Pradesh, or even in case of Maharashtra also. ठीक है, इतना भी आपका sufficient है. Then from mid 1990s the political factors. So political factor क्या होंगे कि basically precedent rule highlights the strong center and weak states, right? But since 1990s आपका center हो गया weak, which was reflected in coalition government. यूपीए हो गया, एनडीए हो गया, whatever. ठीक है, states become strong. How they become strong? First, कि clear mandate in the elections rather than hung assembly. ठीक है, कोई भी एग्जांपल है that's seen in recent यूपी, बिहार, वेस्ट बंगाल इलेक्शंस. ठीक है, सेकंड कि rise of strong politic this regional parties based on state identity. ठीक है, so it made center to impose emergency difficult. ठीक है, so these two major political factors are there. Third, key the LPG reforms were introduced since 1991. So because of that, the stability of the states or state government became important to attract investment. Right? So because of LPG reforms, you need to go for ease of doing business, and political stability is one of the important criteria for any of the FDI or investment decisions by the investors. So the political stability became imperative for it. ठीक है, then की mature or emergence of mature federal culture. ठीक है, फेडरल कल्चर आपका मैच्योर कैसे हो गया? थ्रू द इंस्टीट्यूशंस लाइक इंटरस्टेट काउंसिल्स, जीएसटी काउंसिल और zonal councils which provided platform to resolve the dispute. ठीक है, ये हो गया. तो ये आपके कम से कम कितने हो गए? 1 2 3 4 5 पॉइंट्स तो हो गए. ठीक है. And then as this थोड़ा सा counter argument दे दो कि though frequency has declined, it there are still allegations of misuse. And to ensure the cooperative federalism, you give the way forward. तो पंची कमीशन सरकारिया कमीशन के वे फॉरवर्ड दे दो. ठीक है. सो पॉलिटिकल फैक्टर्स, राइज ऑफ कोalition पॉलिटिक्स, एनडीए यूपीए रीजनल coalitions ensured that center relied on the states for stability. Similarly, rise of regional parties make a dismissal politically costly. LPG reforms shifted focus from political control to economic autonomy for the states. ठीक है. Then this maturation of the federal culture, the growing emphasis on cooperative federal institutions, interstate council, etc. The interstate council was established during that time only, no? ठीक है. Then stable governments in state. So clear majority जब रहती है तो प्रेसिडेंट रूल इम्पोज करने का स्कोप बहुत कम होता है. ठीक है. लास्ट, इंटीग्रिटी ऑफ गवर्नर्स. अब ये फैक्चुअल है, इफ यू नो यू नो. In 1990-91, Governor of Tamil Nadu refused center directive to impose presidential rule. A few governors also. And then, though frequency has reduced, instances like Maharashtra show it is still used. Thus, the way forward is. So, this is the way in which you can combine your conclusion and way forward. Okay, normally that is also fine. You could have simply given way forward, you can given this, and then at the end you could have given conclusion also. In this way I have tried this because I had less space, so I have concluded with way forward.